behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Vargas, who is headed out of lockup at the moment here.
Thank you. What is the? Just leaving. Is this one?
Should be.
Good morning, Your Honor. Agent Brown from probation.
What's the date of the probation violation?
It's August 12th.
Okay. That's the right one. All right, sir, I just called the case. There were appearances placed on the record. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, Your Honor.
Can you put your hand down? Sir, have you taken any medication yesterday or today?
Just.
I don't even know what, but you took something?
Yes.
Anything that would interfere with your ability to understand your attorney or this court?
No.
Any sign of fever, COVID, or other illness?
No.
And is there medication you're supposed to be on that you're not on?
No.
And you had some time to talk with Mr. Goodrich, is that correct?
Correct.
All right, very good. And sir, you were placed on probation and you pled guilty to count 1, police officer fleeing 3rd degree with habitual 4th was punishable by up to life, and count 2, police officer assaulting, resisting, obstructing with habitual, it was punishable by up to 15 years. You were placed on probation, and the court did order that you attend TRICAP. And I have an allegation here that was made by probation, and I signed a bench warrant on August 20th, 2025, and it reads, count 1, on or about August 12th, 2025, defendant left TRICAP without permission. Is that the violation, Mr. Goodrich?
Yes, Your Honor, that is the one we're currently aware of.
Thank you. Are there any amendments?
Yes, Your Honor. There is a pending felony out of 54.
Don't care.
Okay.
Pending means innocent until proven guilty beyond reasonable doubt. When it happens, we'll talk. But I was expecting that count 2 might be that he failed to report to probation anytime after.
That is correct, Your Honor, making that non-technical.
Mr. Goodrich, any objection to adding count 2 failed to report to probation after August 12th, 2025?
No, Your Honor, that is something that we discussed as a possibility.
Thank you. And are you waiving further arraignment?
Yes, Your Honor.
Will this be a plea or a hearing?
It'll be a plea, Your Honor.
Is that correct, sir?
Yes.
Do you understand both allegations against you?
Yes, I do.
And you've had enough time to speak with your attorney in regard to those?
Yes.
And has anyone forced you to plead or promised you anything?
No.
You're pleading of your own free will after you discussed the matters with Mr. Goodrich?
Yes.
And been satisfied with his representation?
Yes.
As to count 1, leaving TRICAP without permission on or about August 12th, 2025, how do you plead?
Guilty.
As to count 2, failure to report to probation thereafter, which would be after August 12th, 2025, how do you plead?
Guilty.
And sir, you understood that you were supposed to report regularly to probation, and you were also supposed to complete all of the court's orders and recommendations, correct?
Correct.
And you failed to do that, correct?
Correct.
And that's evidenced by your leaving TRICAP without permission, correct?
Correct.
As well as you not showing up in probation to show your continued compliance, correct?
Correct.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made, and based on his acknowledgement that he understood the terms and conditions, and he violated by leaving TRICAP without permission and not reporting to probation thereafter to show he's complied with anything. I find by preponderance of the evidence that he's guilty of violating probation and should be held in contempt by this court. Maybe go into sentencing, counsel.
Yes, Your Honor.
What is the recommendation on behalf of probation? And as part of your recommendation, can you tell me whatever he's completed, if anything?
Your Honor, Mr. Bergenquist hasn't completed anything. I checked in with him while he was in custody and then advised him he was going to TRICAP. He unfortunately didn't even make it to TRICAP and jumped out of the van prior to getting there. At this point.
So in the future, tell me that, because he didn't leave TRICAP, he actually fled from the custody of the jail before TRICAP.
Your Honor, to be
Is that
clear,
right?
no, TRICAP comes to pick you up. So
Right.
he was in custody of TRICAP, but that is correct, that he never actually made it to TRICAP, but he was in
Okay,
the TRICAP van, basically.
all right, well, in the future, I'd like to know a little bit more about, see, it sounded to me like he just left in the middle of treatment. He didn't even make it.
Correct, Your Honor.
Okay,
He did not, and I have not seen him since he left, and therefore, at this point, probation would recommend revocation from probation with serving 365 days jail with credit for 306 days.
so he had files in Clinton County. Mr. Goodrich, what would you like me to?
Thank you, Your Honor. Your Honor, it's my understanding that he was sentenced here in January in Clinton County, somewhere around that time, where he was given, I think, 365 days jail. And then this court was suspending it upon placement into the residential treatment. I think he had to complete the Clinton County sentence first, so he made it into August. At the time he was picked up, it's my understanding he wasn't feeling very well and wanted to get looked at. And TRICAP told him, look, well, if you get out, if you get out to go do that, then, you're out. And unfortunately, he made a decision to do that at that point. And then obviously he hasn't been a warrant. He got a warrant and hasn't, checked in with probation since that time. And speaking with him, Your Honor, I think TRICAP was the right plan here. I think that's something he would still really benefit from. He never actually made it up there. I would ask the court to consider giving him one last opportunity to try some type of rehab, whether it's TRICAP or another place, giving him one more opportunity in the residential treatment. I think that is probably in the best long-term interest of Mr. Bergenquist. And speaking with him, and that's the first thing he asked me about being able to do. So we would ask the court to perhaps give him one last opportunity here, Your Honor.
Right, and I'm sorry, how many jail credit days does he have with us?
306, Your Honor.
On behalf of the people?
Your Honor, we just defer to probation.
Sir, what would you like me to know?
I'd like to have an opportunity to complete TRICAP. I know I have had the opportunity and I left without even making it there. I feel like it would be beneficial for me to actually complete a rehab.
So what have you been doing since August? We're in December, so you've been AWOL for what, 4 months?
Just working part-time here and there. Not really much.
And what's the new charge he has pending?
Your Honor, that's a resisting obstructing charge,
Okay.
which the allegations essentially when police wanted to contact him, he took off running because he had a warrant.
Okay. So it wasn't theft or drugs or anything like that?
It was not.
Okay. So tell me what the treatment's for. Remind me. Because I'm looking at this, it seems like you've got some anger issues, maybe some alcohol issues. Is alcohol your thing?
Yeah, alcohol, yeah.
We got any other drugs? Marijuana? I see alcohol, marijuana. What about meth, cocaine, heroin?
A little bit. I've done them all, but the main problem is alcohol.
So when you say you've done them all, Is this something where you get upset and you turn to drugs, or if you can't get alcohol, you use whatever's next, or what?
I couldn't put a finger to it, but just, um,
Well, there's usually a
I-
pattern, you know your pattern.
I'd say alcohol leads to more heavier drug use.
And who are you living with? You couch surfing, are you homeless, what?
Pretty much couch surfing right now.
So we had you in Grand Ledge at 321 Pleasant Street. That's no longer a good address, or what?
No,
Whose address was that?
that used to be my house. I sold it a few years ago.
And you used to work at Two Sons Automotive,
Correct.
so you're a trained mechanic?
Um,
Trained mechanic, what do you do there?
Work on cars.
So you can get employment probably anywhere,
Yeah,
but sir, we don't want you working on our cars if you're high or drunk.
correct.
Anything else you want me to know? Because I want you to know, and this is what I was looking for, I sent you in, geez. 2020?
In this case, I have January of 25.
Oh, this, I'm looking at the Clinton County, okay, yes, okay. Clinton County, in this report, and this is from 2020, it says, during the interview for this report, defendant advised that he does not have drug abuse issues. He has never attended any substance abuse treatment programs and is not currently participating in any program. He does not feel he needs any such treatment. So how do you feel about it now?
I feel like I do need treatment.
Is that because you're in front of me, or is that an honest statement?
That's an honest statement.
Why do you feel you need treatment? What's changed in the last 5 years, aside from multiple arrests? And it seems anger issues. Here's the thing, sir, I don't want to send somebody who doesn't want to be in treatment. I also need you to acknowledge you need treatment, because otherwise it doesn't work. You're just there as a lump and you're taking space somebody else can use. There's resources here for your benefit. Probation was not to harm you, it was to help you. Being in front of judges who send you to treatment is to help you. You've got prison guidelines here. You've got 17 times as an adult you've been in court and you haven't figured it out yet. And you have very serious offenses here. Yet you, in 2020, say you don't need treatment, but these are all the offenses we see for controlled substance. And you've had a lot of really good pleas. So, sir, let's just go to your guidelines. So on the police officer assaulting, 7 months to 46 months. And on the police officer fleeing is 12 to 48. And you're almost out of jail time, so I'm not interested in jail. You're either going to treatment or prison. You walk out of treatment this time, it's prison. I'm not interested. They've treated you soft on all these 17 crimes. You've had the most amazing plea agreements. You had very good attorneys and judges and police officers who've been patient with you despite you wreaking havoc on them. Apparently, people care about you. You don't care about yourself. So what are we going to do about that? Because if you don't want to go to treatment, if you don't want to finish treatment, if you don't want to finish probation, I got a prison and they'll treat you whether you like it or not. But I want some really good reasons as to why I should give you another chance from you, not your lawyer.
Because I'm ready to change.
What has made you ready, sir?
All them, everything that you were just saying, all them 17 different offenses, and I'm just ready to get back to my son's life, really.
And how old is your son now?
He's 6.
Does he even know Dad?
Not as well as he should.
So the crystal ball that I have, and I have the same crystal ball that counsel and probation has, is that if you don't get a handle on this, when you leave jail, take the mini-me outfit. Because kids nowadays can look up everything on the internet and you are there. He's gonna see his father. He's gonna see the picture of your mugshot, of all those things that happened to you. And so when he's a teenager and out of control, he's gonna say, well, you did it, Dad. And he's gonna think it's cool because Daddy did it. And we see generations. And I've had, in the last 5 years, I've been on the bench now 20 plus years, but in the last 5 years, twice it happened. I thought once was astronomical odds, it's happened twice, where a father and son have not seen each other for a decade, and where did they see each other? In my lockup. Is that history you want for you and your son?
No.
Then it's up to you to change it, sir. The only one who can change it is you. And you have to teach them that every mistake is a teachable moment that you learn from, and that every time you try, you are doing good. So. He's going to be on 3 years probation. We'll increase it to 5 if he slides back. He's going to go from jail to TRICAP or any other agency that you find appropriate for his issues. He will complete the program, residential, and this should be long-term residential, and any aftercare. He'll sign all necessary releases. And is there any other, you're not still answering to Clinton County. It's just me now. All right. And then I think because of the way I sentenced him, I need to go through all of the probation courts because he was running concurrent with Clinton County, right?
Again, I wasn't at sentencing, but I would guess that would have been part of sentencing back in January as far as all the orders.
Yeah, I don't know. Does he have the standard orders in place?
He does, excuse me, he does, Your Honor, and I did meet with him and went over all of the probation
Okay.
conditions while
So-
he was in custody.
All right, so you're reading of those, and is there anything that I need to amend further?
No, Your Honor.
Okay, so he gets 365 days of credit for, well, he'll get credit for 306 plus any other days that he serves awaiting a bed. He's not to be released except to residential treatment.
Your Honor, one last thing I'd like to put on the record is he does have that other file right now where he currently has a 15,000, 10% bond on.
That will turn to a PR bond upon going to
Well,
residential.
that's not your case yet, so I have to deal with Judge Flores there. So I believe at the end of our district court time, I would hope that he would be able to agree to that and have him sent there. Well, the case is probably headed in your direction eventually.
Yeah, I can't imagine Judge Flores standing in our way, but I will, if it gets here, it'll turn into a PR bond.
Okay.
So that's not, I've said it on the record, we'll deal with that paperwork, depending how it falls. And Is there anything else we need to amend?
No, Your Honor.
And so he'll be part of a worksheet program, all of that should be in there, if it's not, we'll deal with it later. I expect him to be employed, attending AA, NACA, having a sponsor, all of those things. And that should be part of the aftercare program.
Yes, Your
And then you make up your mind based on how he's doing, whether you want to see him once a month or every other week or whatever. Once in person, once a call in, I want to make sure we keep tabs on him. Sir, don't run away. Because you're gonna run into prison. You can ask me to jail. I say what I mean. You gotta give today, it's your last day for this court.
So here's your appellate rights if you wanted to appeal the judge's.
You have 42
sentence.
days to appeal to request appellate counsel. Do you now receiving that?
Yes.
You're welcome.
Thank you, Your Honor.
Thank you, Your Honor.
See ya.
Anyone else heard?
Commissioner, I believe they're bringing up Mr. Gordon. And then we're ready on Gramza too.
Gordon and who?
Gramza?
Rams.
Gordon and Graham.
Gordon?
He's on the way up.
Perfect.
Okay, and after that will be Grandson.
Graham's is not here.
It's gonna be a bench warrant request for
Oh,
Gramza.
then let's do that now. While we wait. All right, this is docket 25-5462 MH, People of the State of Michigan versus Michael David Grams. Counsel, your appearance for the record.
One, Your Honor, Natalie Maycomber on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Michael Gramza, who is not present.
All right, do we know if he was scheduled for 9 o'clock, it's now a couple minutes before 10, or actually 10 o'clock now. That clock's a little slow. Court is waiting an hour for him, appears he's not going to appear. Do we know if he was properly served?
Your Honor, I don't know if he was properly noticed. He was at Bear River the last time we were here and we adjourned it so that he can appear by video. I was trying to get that information to Bear River, but I've come to find out that he left Bear River on the 25th. Well, he was discharged, but it was discharged for rule breaking. So he has not been in contact with his mother, who I reached out to, who would have provided him notice to. And I reached out, he's in probation in Victoria with Judge Buchanan, and I reached out to the probation department. They haven't heard from him. So I didn't expect it.
I appreciate all the extra work. Bench warrant bound forfeiture.
Thank you, Your Honor.
Brian?
Yeah.
There's a status conference on, I suspect it might be going into. Right.
That one got moved because they don't have
Is it?
yeah, they don't have the transfer yet.
We don't have, so we're waiting on the acceptance.
Acceptance.
By Washington County.
That's what it is.
Oh,
He has
okay.
to hold us for another status conference in 30 days. But we can transfer it before that.
Okay, then we'll take it off.
Yeah.
Is he in custody or not?
No.
Okay.
That was the word I was looking for that I could not find.
running a little short.
Okay.
I apologize.
That's no problem, just the way it goes. So something, always something.
Gordon, we're set for trial on the 23rd, but we work back up to a civil trial. Do you know if that civil trial's gone?
I suspect it is valid.
Yeah, I think we purposely did that.
Yeah.
Just so that I can have some certainty in if it's gonna be.
Yeah, because in that case. This is fine, this is the final.
It's fine.
I think at some point he was gonna.
He was, and then he
Okay,
didn't,
Okay,
yeah.
that was the, okay, just wanted to make sure my memory was correct.
Were you impressed that I knew that what you were saying, even though you didn't finish the sentence?
Yeah, well, we worked together long enough where, yeah, you knew that's what I was gonna ask.
Yeah.
Go right on up to the vote.
No.
This is docket 24-574 FH People State of Michigan versus Christopher Gordon. Counsel, your appearance for the record.
Good morning, Your Honor. Angela Delvero on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, on behalf of the defendant.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. And put your hand down. Have you taken any medication yesterday or today?
Yes, Your Honor.
Okay, you don't have to bow toward the mic. It's picking you up. All right. Is it anything that would interfere in your ability to understand your attorney or the court?
No, Your Honor.
Is it medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with Mr. Freeman?
Yes, Your Honor.
I know you've been in front of me a few different times. This is a date for a final pretrial. We have a trial scheduled in a couple of weeks. And you've had enough time to talk with your attorney about the final offer of people. Is that correct?
Yes, Your Honor.
On behalf of the people, what is that final offer for the record?
Certainly, Your Honor, this is a plea offer that's been extended to the defendant for probably close to a year. This case has been set for trial a number of times and adjourned a number of times for older cases that went to trial in its place. The plea offer, as has been for quite some time, as I stated, is the defendant would plead to count 1, which is a CSC second. The people would dismiss count 2, which is another count of CSC second, and count 3, which is a misdemeanor domestic violence. The benefit to the defendant under that plea offer would be that his guidelines as charged were 36 to 71 or are 36 to 71. Under the plea agreement, they would have gone down to 29 to 57. It's my understanding the defendant is not desirous of accepting that plea offer and wishes to have his trial.
Is that full, fair, accurate, and complete, Mr. Freeman, in regard to the plea offer?
It is, Your Honor. Thank
And
you.
that's what you've discussed with your client?
I did.
And I have that same offer in my notes previously, so sir, you've heard it once again. And you've had enough time to talk to your attorney. Is it your, and the plea offer that was stated is full, fair, accurate, and complete, what you've been discussing, is all of that correct?
Yes, Your Honor.
And your attorney has indicated you wish to go to trial?
Yes, Your Honor.
Okay, and, did anyone force, threaten, or coerce you to make this decision?
No, Your Honor.
Anyone promise you anything that caused you to make this decision?
No, Your Honor.
And you made this decision of your own free will
Yes, Your Honor.
after discussing it with your attorney
Yes, Your Honor.
multiple times at this point, right?
Yes, Your Honor.
And I know at one point you were going to take a plea, and then in the midst of that, you changed your mind. So you understand I have to have a cutoff date. I think we've had this conversation before, so that I don't allow people to plea except under extraordinary circumstances on the day of trial, because if you changed your mind the day of trial, you would have taken up some other person's date for trial. So that's why I have this cutoff. It's not to pressure you, but we need to not waste docket time and also resources of subpoenaing witnesses. So you understand all of that?
Yes, Your Honor.
All right, and you wish to go to trial?
Yes, Your Honor.
All right, and you've been satisfied with the representation, Mr. Freeman?
Yes, Your Honor.
All right, we have a trial date, when is it?
It's January 23rd. I was able to look, there are other criminal cases scheduled that day, but we are the only in custody case and by far the oldest date. At the time that we set this trial, I think we were back up to a civil case. I don't know what the result is of that civil trial. Or if it's been-
I'll have to go to my office.
And he'll verify that, and it might be that even if you're back up to a civil trial, we can move that civil trial for back. Those have a way of resolving themselves, so we'll just keep on top of that, because even though they haven't settled today, and they know that I won't move their trial, suddenly I get, yeah, settlements.
Sure. Otherwise, Your Honor, we are prepared, the people are prepared to go to trial. All pretrial motions have been resolved with orders that were dated, let's see, in September. So where other acts has been ruled admissible in September, tender year statements have been ruled. So I didn't notice an expert. This is an immediate disclosure, so I think we're good to go.
Are you awaiting anything, or are you good to go?
No, we're good to go, Your Honor. I'm thinking 3 days if Ms. Delvero, just for the court's planning.
Going on,
Yeah, I mean, it's because there's no expert, it should go faster. Yeah.
but there's deliberation time, and we
Sure.
Wednesday, so it's basically a week trial.
Yep.
So if it's 3 days, then I'll pick a jury the following Friday, so,
Okay,
or if they're deliberating, I'll pick a jury.
okay.
We'll figure it out. All right, getting what you need at the jail, sir?
I believe.
Okay, so you and Mr. Freeman have a few weeks to prepare for trial.
Your Honor, my client broached a topic with me that I said I would just bring up with the court. Given the length of time that he has been in jail, it would be useful for me, certainly in terms of trial preparation, if he was out and about versus in the jail. Would the court consider establishing a reasonable bond such that even with a tether so that he and I can communicate more effectively? If for
Well,
no
they
other
don't
reason?
have a bond report, and I have a Florida address, so, and then I also have a Clifford Street address. And with these kind of charges, I'm not likely to do that, but I'll hear from the people.
Your Honor, the people would oppose any bond reduction. This is a motion that's been brought before Your Honor previously, which you have denied because the defendant does have an extensive Florida criminal history. And if I'm not mistaken, has a warrant out of Florida. If I recall,
I think you're right, actually.
and so I would ask the court to deny the motion.
I'll deny it at this point. If you find something different, let me know, but I don't think it's wise to release them, and it looks like the likelihood of success on the people is high, so from what they've indicated previously and today, so I'm not interested at this point.
I understand. Thank you.
Thank you. That's all for this record.
January 23rd, yep.
You know, I have to ask.
Yeah, I know. Yeah, we always make a record. Perfectly fine with me.
Thank you, Ms. Delvero.
Yeah.
If I can approach, I have a form on Clark.
This doesn't want to stay up, does it?
Not with this tape, I don't know. Put in a request, they got this in right, it's just a
It's okay.
request.
Yeah, I'll do that.
I don't know, everything is ordered different size, I don't know.
Just need contact. Is it coming through? Guard. It's 11:30. What's up?
We're waiting for Mr. Fibelson to come back in, and he admittedly told me something, and I forgot what he told me about the case.
But what?
The case, he said something to me about it, and I forgot what he said. Mr. Fibelson, on
Oh.
the word.
Okay.
So I don't know what to tell you.
Okay, that's
I
fine.
forgot.
What about, Jones?
Jones, we're waiting for Mr. Kaplan.
Okay.
Hampton, Mr. Campbell is here on Hampton, but I don't know where he went.
What about Perkins?
Perkins, I've not seen Fred yet.
Is he in custody?
Yes, Perkins is, yes.
Okay. Okay. We're dealing with Garza.
Yes.
All right. Garza, have you met for pre-trial on him?
We had, the case has been ongoing for a while now, Your Honor, but he was out for an extended period of time, so we would probably just send this for a pre-trial, something like that.
Okay.
Look at the case, set eyes on it and see if we can get something figured out.
Additionally, it was marked as Adams, but Adam told me yesterday that it was not his, so. I don't know a whole lot about
Right.
the history of the case.
Perkins looks like it's Aaron Schroeder.
Perkins?
Yeah,
Yeah, we're talking about Garza. I just wondered.
yeah, but
I said,
you said Fred Blackman, so I was just, it looks like it's
oh,
Aaron Schroeder.
well,
That's like right on the weapons. It's right on the weapons.
I just see it was.
Is that what's like?
That's weird.
Yeah, better
This is docket 25-842 FH. And 25-845 FH, people of the state of Michigan versus Lorenzo Freddy Garza. Counsel, your appearance for the record.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth assistant public defender here on behalf of Mr. Garza on both files. He's standing to my right at the podium.
Good morning. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
You put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had any time to speak with Mr. Starks?
Yes, Your Honor.
And sir, I have two bench warrants, one for each file. In docket 25-845 FH pending, you have count 2 stalking aggravated felony punishable by 5 years. Count 3 malicious destruction of a building, $200 or more, but less than $1,000, and that's a misdemeanor punishable by 1 year or $2,000. And count 4 telecommunication services malicious use, a misdemeanor punishable by 6 months and or $1,000. And then on docket 25-842 FH, you have pending count 1 home invasion first degree, felony punishable by 20 years and or $5,000. Count 2 assault with intent to do great bodily harm less than murder or by strangulation, felony punishable by 10 years or $5,000. Count 3 misdemeanor domestic violence punishable by 93 days or $500, and count 4 unlawful imprisonment, a 15-year felony and or $20,000 with the habitual offender second offense notice on the primary offense. That would be 1.5 times, so the 20 years turns into 30 years. Do you understand all of that?
Yes, Your Honor.
We had a pretrial. And you failed to appear for that. And so I have a bench warrant that was requested by pretrial services, and on each file it says you should be held in contempt for failure to appear to a criminal pretrial conference on September 30th, 2025. That would be before this court. And then you should be held in contempt because you failed to appear. I'm sorry, you violated your curfew, 9 p.m. to 6 a.m. curfew on the following dates: July 29th, August 22nd, August 27th, August 29th, August 30th, and September 1st, 2025. Are those the allegations that you have discussed with your client, sir?
Yes, Your Honor. Thank you.
And are you waiving further arraignment?
We waive further range. Yes, Your Honor.
Will this be a plea or a hearing?
I would like to proceed this morning. You have the option of you could admit responsibility of the violations, or you could request a hearing.
Sir, it's not whatever. Do you need a few moments to talk with your attorney? You have a right to a hearing. You also have a bench trial, and that would be not beyond reasonable doubt for violations of this. It would be by preponderance, which means more likely than not. And your rights remain intact. If you don't choose to plead, the people would have the burden of proving your guilt by preponderance of the evidence. You would be able to cross-examine any witnesses and evidence. You could also bring witnesses and evidence in your defense. The court would order those witnesses to be present. You can remain silent. Your silence cannot be used against you. However, if you choose to testify, then the people could cross-examine you. Do you understand all of that?
Yes, Your Honor.
Do you need a few moments with your attorney?
That's what you'd like to do?
Yeah, I did.
Okay.
I don't know what else to say.
You're gonna do what? Plead?
Yeah, plead guilty, that's right.
Okay. Do you understand the violations?
Yes, Your Honor.
Okay. And sir, as to these apply to both files, so I'm just gonna read them once. That's fine with you, isn't it, counsel?
Yes, Your Honor. Thank you.
All right. failure to appear before this court for a criminal pretrial conference on September 30th, 2025, pending plea.
Guilty, Your Honor.
And violating your 9 PM to 6 AM curfew on July 29, August 22, August 27, August 29, August 30th, and September 1st, all of 2025, pending plea.
Guilty.
Did anyone force, threaten, or coerce your plea?
No, Your Honor.
Did anyone promise you anything that caused your plea?
No, Your Honor.
You understood that you needed to regularly appear before probation, follow all the rules, including your tether, your curfew rules,
Yes, Your Honor.
and you needed to appear for all hearings and proceedings, including the criminal pretrial conference, and you failed to abide by that. Is that correct?
Yes, Your Honor.
And you've pled of your own free will
Yes, Your Honor.
after you've spoken with your attorney,
Yes, Your Honor.
and you've been satisfied with the representation of your attorney?
Yes, Your Honor.
I find defendant is in contempt of court for failure to appear for the criminal pretrial conference on September 30th, 2025, and numerous dates. He violated curfew, the standard of preponderance of the evidence. And more than that, he's admitted that he understood what he was to do and not do, and that he violated in regard to those 2 counts. Can we go to sentencing?
Yes, Your Honor.
Yes, Your Honor, thank you.
What is the recommendation on behalf of the people?
I think Your Honor, people would ask the court to find the defendant in contempt and sentence him for 93 days. The charges that he's facing obviously are very serious in nature, quite honestly, a little scary in nature. The fact that he just took off and was not reporting, was unable to locate where he was. On top of that, Your Honor, he originally had a $5,000 cash surety bond. This court granted him a PR bond graciously with a tether, and he still chose not to follow those bond orders and basically told this court that he didn't care about the orders. So based on that, we'd ask the court to sentence him to 93 days of contempt.
Response?
Thank you, Your Honor. Mr. Garza had some struggles when he was out in the community. He's very sorry. He had some personal challenges. Life just kind of threw him up some obstacles, and he did not respond very well to that, but he's very sorry. He turned himself in. He turned himself in over the weekend. He understands the urgency here and the importance, and he's here to own up to his responsibilities. And he admitted that he committed those violations, and he's very sorry that he did. And he has a child on the way, apparently next month. So he has a lot of very powerful motivators now for him to clean up some of the poor decision making that he was doing previously. So I respectfully, Your Honor, I would just request that he be given credit for the days that he served so far, which would be 4 or 5 days at this point. And I would request that Your Honor reinstate some type of cash surety bond for him. He's indigent, so he would not be able to afford a high cash surety bond. Thank you.
Sir, what would you like me to know?
Kid on the way.
Everybody's got a kid on the way.
Right, my daughter's gonna be born in a month, and my top of that doing, my grandpa, I'm doing a whole bunch of stuff I'm going through. Life's not been good, and I'm facing these charges that's against me for, and I've been doing this for what, 2-3 years now, and still haven't got seen. I don't got no offer, no nothing.
Well, in order to have an offer, sir, you have to show up to the pretrial. That's where the offers come. We can have a pretrial today if you like. And this has been pending in 2024, and I ended up with not 1 file, but 2 files. So, sir, you, during the course of this, impregnated your girlfriend. You knew you were having a baby. I'm not releasing you for the birth of the baby. You're gonna clean up your act, sir. And if you don't, and you can do your research. I used to do this when I was a practicing lawyer. And if you don't believe me, when you're out, just go sit on the 2nd floor and watch. Parents who do not pay child support, parents who have a criminal history and continue to violate the law are not deemed fit parents. And after, if you're lucky, a court will give you a chance to raise your child because it is a constitutionally protected right, but you have to be a fit parent. after a certain time, the court has the authority to terminate your parental rights. Because that child deserves a fit father and a fit mother. So get your act together if you really care about that child. And if you don't, continue this behavior, don't show up to court, don't show up for the child's life, don't show up. And the court will show up and terminate your rights. This state is unkind in that regard. So get your act together, sir. There is no bond. I wrote on the last time, as I gave you already a deal on getting out, I wrote on this file, I probably told you at that time, don't release if it fails to appear again. And don't tell me about delays, these are all on you. You personally, not counsel, they've been here every single time. I've been here, the prosecutor's been here, everybody's been here to play, let's make a deal. That's done at pretrial conference. But they can't proceed without you. We get a whole lot of people and a whole lot of county money involved to do insurance. And then law enforcement has to get involved and arrest you. And you can turn yourself in, but you should have taken care of business as a free man and stayed free. And all this would have been handled months ago. So there'll be no bond. 93 days contempt, credit for what, 5 days?
I need to turn yourself in, sir.
6, 8, 7.
I apologize. Yeah, let me just double check the jail's website, Your Honor.
Do you have time for a pretrial stay? If not, we can put it another day. I just hate to have the jail transfer back and forth when he's here. I don't know if you probably don't have time to even contact the victims.
We have not contacted.
All right,
I have not.
so we'll set this.
I believe it is 5 days credit, Your Honor. He was booked in on the 28th.
Okay,
That's correct, Your Honor.
great. Council, are you here? So Wednesday in January, we could just have it, a pre-trial when you're already here?
Absolutely, Your Honor. Mr. Garza would greatly appreciate the earliest date possible, and I respect that. I can make sure that if I'm not here, I can have something covered for me. Thank you.
How much time do people need to figure this out? I mean,
Not
let's do December 17th, or, oh no, we can't. I don't know if we can do December 2nd. Might be able to. I mean, we can do next week, but you might need more than that, otherwise we can do January.
I think we would need more than next week, Your Honor.
How about the 17th?
17th, we can make work, yeah.
Okay, December 17th. I may be in hearing, but I'm not needed for the pretrial. This is gonna be a plea, and you can set it with according to my schedule.
Thank you, Your Honor. December 17th, at what time again?
Would you like 9 or 1?
9.
9.
Okay, pretrial. Sure, you'll be brought over before then, or on that date, and, prior to that, you need to work with your attorneys.
Thank you, Your
And
Honor.
let me just have a quick reminder, no contact with any victim.
All right, thank you, Your Honor.
And tell me this, are any of the victims in these files the mother of your child?
No, Your Honor.
Great, thank you. That's all for this record.
After right now, good time for a mid-morning break. You got the crunch back there.
I'm leaving
We don't have any.
Charlotte's not on.
Oh, that's,
Just Fred.
oh, that's what she emailed about it yesterday.
Who's next?
Well, I don't know, because we're waiting on attorneys.
Figelson's on Zoom.
Oh,
Ryan, is Miss Sager on Zoom? I was under the impression she was. If not, if she is, we can go if the court's ready.
I'm just waiting. I don't see, is it Sager?
Yes,
Is that what
I
you
think,
said?
yes. She told me she was on.
Ms. Sager, are you on?
Yes, ma'am. Yes,
Okay. Can you put your camera on?
yes.
Okay.
Get it? Yep, I got it.
All right, this is docket 25-1034 FC, people of the state of Michigan versus Amber Darlene Sager. Counsel, your appearances for the record.
good morning, Your Honor. Natalie Maycomber on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Amber Sager, present by way of video conferencing today.
I'm Amber Sager.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
All right, thank you. And is everyone in agreement that defense counsel and defendant appear by Zoom?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. And what are we doing here?
Thank you, Your Honor. This morning is set for a plea I'm looking to see if, I don't know if we filed the amended information, so it'll be a plea to the added count 2.
I don't have amended information. I do have a bench warrant.
I believe we
Did we deal with that?
last.
We did, Your Honor. Yeah,
Okay.
a couple weeks back.
Okay. Know that. All right, good. Okay. So what is count 2 now?
Count 2 is an assault with intent to do great bodily harm less than murder.
Do we have the paperwork?
It doesn't look like it was sent. I'll get that sent over to your office.
Okay.
Judge, we did review the paperwork. I just don't think it ever got signed when we were in front of the court a couple weeks back. I thought it was.
All right, so ma'am, are you still living in Brooklyn, Michigan on Spicer Road?
Yes, ma'am.
And at the time of count 2, this offense that you're going to be pleading to, were you on probation, parole, bond conditions before another judge?
No,
Okay.
I don't think so.
Are you a US citizen?
Yes, ma'am.
And who do you live with?
My mother.
And have you taken any medication yesterday or today? I don't need to know what, if any, just have you taken anything?
Just my prenatal.
And are you supposed to take other medication that you're not on?
Some psych meds, but it would be harmful to the child, so.
Okay, and you're okay without those meds?
Correct.
You're able to understand your attorney in this court?
What was that?
You are able to understand the court and your attorney?
Yes, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Are you working?
I am looking at pregnancy-friendly jobs right now, but I can only do part-time because I'm waiting on disability.
Okay. And Mr. Feigelson, do you believe she's oriented to date, time, and place, and does understand what's occurring?
Yes, Your Honor, I do believe that to be true.
Okay. What is the plea agreement on behalf of the people?
Thank you, Your Honor. The agreement in this files for the defendant to enter a guilty plea as to that added count 2 of assault with intent to commit great bodily harm less than murder. Upon successful plea and sentencing, people will move to dismiss count 1.
And was the victim contacted?
Yes, Your Honor. Additionally, there is a killable agreement to no further upfront jail at the time of sentencing, so long as the defendant agrees to any and all terms of probation deemed appropriate at sentencing.
Is that full, fair, accurate, and complete, Mr. Feigelson?
Yes, it is, Your Honor.
Ma'am, did you hear the plea agreement?
Yes, ma'am.
Is it full, fair, accurate, and complete?
Yes, ma'am.
And counsel, are you waiving reading count 1?
Yes, Your Honor.
As to the reading of the added count 2 on the amended complaint?
Thank you, Your Honor. The people of the state of Michigan versus Amber Darlene Sager, case number 25-1034 FC. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about January 1st of 2025 at 488 Waldo Road in the city of Mason, Ingham County, the defendant did, in count 2, assault with intent to do great bodily harm, less than murder, did make an assault upon Mallory Ann Haynor, Haynor, with intent to do great bodily harm, less than the crime of murder, contrary to MCL 750.84. This being a felony punishable by up to 10 years or $5,000 in fines. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at the time of arrest. This being done against the peace and dignity of the state of Michigan.
I'm sorry, so 15-year felony?
10 years.
I'm sorry, 10-year and or?
$5,000.
And ma'am, did you understand what was just read? I'm just trying to be frozen. Ma'am, can you hear me? Can you hear me, ma'am? Did you hear that?
Yes, ma'am.
So you understand count 2, assault with intent to do great bodily harm less than murder is a felony punishable by 10 years and or $5,000, and you would have to pay restitution to the victim for any personal or property damage.
Yes, ma'am.
And was your DNA, is it already on file?
It should be, yes.
And did they swab you when you got arrested?
I don't remember. I was intoxicated, but I know in Jackson County they have my DNA.
Okay, great. So tell me this, there's going to be a plea. Do you remember what happened on this particular day or not?
On the day of the assault?
Yes.
Not fully, a little bit.
Do you remember enough that you came in contact with Ms. Haynor and what happened?
Yes, ma'am.
Okay. Ma'am, as to your rights, I don't have a signed or advice rights form, so I'm going to read them to you, unless counsel, have you already gone over those with her?
I believe I did, Your Honor, but we can go over those again. I have no issue with that.
And you have the right to a bench trial, which is by judge alone, or a jury trial. You have a right to have the people keep their burden of proving your guilt beyond a reasonable doubt. If they can't do that, then the case would have to be dismissed. You have a presumption of innocence until they prove your guilt beyond a reasonable doubt. And you have the right to have all witnesses and evidence appear at trial, cross-examining any witnesses and evidence. And you have the right to choose to provide a defense, but you don't have to. If you want to provide a defense, any witnesses you want, the court would order to be present, and people can cross-examine any witnesses and evidence you bring in your defense. You also have a right to remain silent. Your silence cannot be used against you in any way. However, you also have a right to choose to testify. If you chose to testify, the people could cross-examine you. Additionally, by choosing to plead, you're also giving up your right to an automatic appeal. If you have a trial, there's a right to an automatic appeal, so the Court of Appeals must take a look at anything you're unhappy about. But now it becomes their decision, and they will not take up your case if they choose to not take it because they think that your issues are not important. Do you understand all of that?
Yes, ma'am.
All right. As to count 2, assault with intent to do great bodily harm less than murder, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plea?
No, ma'am.
Anyone promise you anything other than the plea agreement that caused you to plead?
No, ma'am.
You chose to plead after you consulted with your attorney?
Yes, ma'am.
You've plotted of your own free will,
Yes, ma'am.
and you've been satisfied with the representation of your attorney?
Yes, ma'am.
And do you understand that if I violate the Killebrew, if everything goes well, you're doing fine on bond conditions at sentencing, if I violate the Killebrew for no further upfront jail at that time, then I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. However, if you violate the law or bond conditions between now and sentencing, I can violate the Killebrew and not allow you to withdraw your plea. Do you understand that?
Yes, ma'am.
Additionally, I don't know if there's going to be restitution or any personal or property damage, but if you disagree with the amount at the time of sentencing, then I would allow your attorney to set a restitution hearing, and I will determine the amount can go up, it can go down. Do you understand that?
Yes, ma'am.
Did this occur on or about January 1st, 2025?
Yes, ma'am.
In the township of Wheatfield, county of Ingham, state of Michigan,
Yes, ma'am.
at a specific location known as 488 Waldo Road in Mason?
Yes, ma'am.
And did you come in contact with Mallory Ann Haynor, Haynor?
Yes, ma'am.
And did you know her?
Yes, ma'am. She's actually the one who picked me up from my house.
Okay. And did you and she have some kind of disagreement?
Yes, something of mine came up missing and I was attacked.
You were attacked?
Yes.
So did you fight back?
Yes, I did.
And did you end up assaulting her?
Did I end up what?
Assaulting her.
Yes, ma'am.
So you were attacked. When you assaulted her, was this in self-defense?
Yes, ma'am.
How did you assault her?
I stabbed her.
You slapped her?
Stabbed.
You stabbed her?
Yes,
And
ma'am.
did she have a weapon?
She had something glass in her hand.
She had something, did you say flash in her hand?
Yes.
Glass.
And it was also two other people assaulting me with her.
I'm sorry, what did she have in her hand?
Something glass.
Something glass
glass.
in her.
I see.
It was
So,
a paraphernalia pipe.
okay. Counselor, gotta help me out here, because this is self-defense, we're going to trial.
Yeah, Judge, I can help you out. Miss Sager, she did have a pipe in her hand, is that correct?
Yes, sir.
But she wasn't using it as a weapon, is that correct?
Not that I can remember.
So
I
there was,
have been stabbed in the face with one before though, and it kind of triggered me.
I get that, but there was 3-on-1 and nobody else had a weapon and you used the weapon to end the fight essentially, is that correct?
That's correct.
Judge, I think that's enough to satisfy against the defense of self-defense.
I don't know, know, 3 against 1, it might be appropriate to have a knife, that might be a situation to go to the jury with. Unless we can make for the record. I mean, maybe
I'd rather-
you felt that you were so threatened you had to use a knife, did you announce, I'm going to use a knife if you don't get out of me, get away from me, or what? What happened here?
I was in fear for my life. I have severe scoliosis and I was told if I get hit the right way, I'd be paralyzed. But I'd rather not go to trial.
Well, I'm sure of that, but I would rather not be appealed. Because then you go to trial anyway. We have to make what we call a good factual basis, and I wanna make sure this is clean, and I'm not so convinced. On behalf of the people, is there something we're missing, or is in the police report that we have not made a record of that she might not remember because she was intoxicated?
I believe so, Your Honor. But if I could ask Ms. Sager first. Ms. Sager, the altercation that you were in that lasted about 45 seconds, is that accurate?
I wouldn't remember.
But that altercation actually ended and the participants, including Ms. Hayner, went to a separate room before you stabbed her, correct?
I don't recall.
If that's what it says in the police report, you're not doubting it, is that correct?
What was that?
If it says that in the police report, you're not doubting that, are you?
No, I wouldn't.
And that would be because of your intoxication, lack of memory, or fuzzy memory, is that correct?
Correct.
Your Honor, would the court prefer to have the police report?
Any objections to me reviewing that, Mr. Feigelson?
None, Your Honor. I've got the report here, so I know where Ms. Maycomer's looking at.
All right.
I think it's on page 4 and 5 of the report, Your Honor.
Thank you. I don't know changes to a no contest plea because she has acknowledged most of this, but I like to make for the record, as you know, because this could be deemed by the record we made one of self-defense and should go to trial or have to be further reviewed. So let me look at this. And for the record, this is Ingham County Sheriff's Office, and it did occur January 1st, 2025, 12:06 a.m. at the 488 Waldo Road, Mason, Michigan address. And it is their report, case number 25133000001. And it does indicate the victim is Mallory Ann Hayner. And there is a witness known as Melanie Renee Herrick, Herrick. Another witness, Michael Allen Heiner, Hiner. And it does indicate that defendant was arrested. When officers arrived, Mallory was holding pressure on her wound, which was located on the right side of her upper chest with her hands, and shirt were covered with blood. They applied pressure. They interviewed the witness, and she stated Amber was drunk and was accusing everyone of stealing her wallet. And she had confronted Amber about the accusations, and a fight ensued inside her bedroom. Amber attempted to grab a glass lunch item and hit Mallory over the head. Melanie said she wasn't exactly sure what the item was, but it was a glass object. Melanie took the item from Amber. Melanie advised that the altercation lasted approximately 45 seconds before they agreed to separate. And Mallory and Melanie went into the kitchen. Amber stayed in the room. Amber then ran out of the room and stabbed Mallory before retreating back into the bedroom. It appears there was time to reflect on the court would accept this. The question I have for counsel is that do you want the plea to stand as a guilty or no contest?
Judge, I would ask the plea stand as a no contest.
I'm on board with that, Judge. I agree with that.
All right, this plea should be no contest, and ma'am, that would be based on your intoxication, which is clear in this report. I think we've made a factual basis, all right? So your plea is going to be changed to no contest based on your lack of memory due to intoxication. Do you understand that?
Not exactly. What does that exactly mean?
It means that you really can't remember, but we have enough evidence that this would hold up, you're guilty, but you don't remember, so there's no contest plea because we've taken it from other sources, the factual basis to prove the elements of the crime. And it has the exact same effect as a guilty plea, but it's just an indicator that you're not contesting the facts that are in the police report. They stand as the evidence because you're not able to make a full and accurate description of what happened. Does that help?
Yeah, so does that mean I still get a lesser charge still, or?
Yes.
Okay, that's what I was trying to
It has,
understand.
it has the same effect, it just, in the legal world, it just means you, for some reason you didn't remember, or there could be civil liability, there could be lots of reasons for no contest plea.
Okay, I understand better now. Thank you.
Okay, all right. Counsel, anything you want to add to that?
No, Your Honor, I can talk with her offline if you have any questions, Ms. Sager.
I do,
Well, call
there
me
any-
after the record, and then we'll do that.
Okay.
Okay.
On behalf of the people, any further record or questions you'd like to ask, or me to read anything from that police report?
No, Your Honor, thank you.
No, no, Your Honor.
Our counsel word promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Is court compliant with the court rule?
Yes, Your Honor.
Yes, Your Honor.
I find defendant's no contest plea to be appropriate based on lack of memory, and the police report does have all the elements. I also find that the no contest plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find, as I said, there are sufficient grounds to accept defendant's no contest plea. The evidence is very clear in the police report and actually substantiated by her own comments as to what she remembered. Therefore, count 2 will enter. Count 1 is hereby dismissed. Additionally, any outstanding warrants related to this file, if any, are also recalled and dismissed. Any weapons that were seized or contraband that was seized are hereby forfeited. And we have sentencing date?
January 28th at 11.
Councils that meet with your schedule?
Yes, it does, Your Honor.
All right, ma'am, when are you due?
June 18th.
Okay, so you'll have 24 hours, and Mr. Feigelson can give you this number, but it's 517-483-6100. They'll have 24 hours to call probation and make and keep an appointment. They can probably do this on Zoom as well. So you don't have to travel, but you need to call them immediately. If you have any trouble reaching them, reach out to Mr. Feigelson and he can help you. We need a pre-sentence investigation report because I can't sentence you without it. Do you understand?
Yes, ma'am. Can I get that number one more time, please, so I can write it down?
Yes, 517. 483.
483.
6100.
6100. Okay, and that's Jackson County probation?
No, that's Ingham County, so you have to deal with our county, they'll reach out to probation, you'll sign a release probably to let them know that they need to coordinate. You can have it transferred. Are you still on in Jackson County or no?
No, ma'am, I was never on probation.
She just lives in Jackson.
I was as a child, but that was as a child.
Okay, so here's the deal. You live in Jackson, and so you still have to deal with our county. We'll allow all this by Zoom as long as things are going well. And so Ingham County, once I sentence you, Ingham County probation will reach out to Jackson. So Jackson will monitor you for us, but right now they don't know anything about you. So it all has to go through in different stages. So we'll let you know, okay?
Okay, yes, ma'am.
So keep reporting to Ingham until you are told otherwise, okay? Bond conditions continue, and the no contact order with Ms. Hayner is also continued. So you may be friends, I suspect that friendship's over, but you're not to contact her in any way. Do you understand that?
Yes, ma'am.
All right, anything else?
No, Your Honor.
Yes, I have one question.
Is it for me or your lawyer?
Whoever, I guess.
Okay,
I
what's
don't
the
know.
question?
So I'm scheduled to take a drug test today in Lansing, and my mom's having severe chest pains today, and my sister can't take me at the hours they have. Is there any way I can make it up tomorrow?
Mr. Feigelson, maybe you can deal with pretrial services. It's fine with me. She
Okay.
hasn't had any positives, and I suspect that if she is positive, then CPS is gonna get involved. There's gonna be a whole lot of other things going on,
Judge,
so.
I can reach out to pretrial services. We'll see them in a minute. Yeah, okay.
And if they need an order, we can do a quick order here. Just see, let Ryan know.
Yes, who's your worker, Amber? Do you remember who your worker is?
I have Jessica Emmons,
Okay, I'll let her know.
and I continue, even though I'm put on probation, do I continue to talk to her every week?
Yes.
Yes, until sentencing, okay?
Okay, I just wanted to clarify.
Yep, that's good. Thank you. That's all for this record.
Thank you, Judge.
Thank you.
Thank you.
January 28th.
Okay. Now,
Yeah.
ready.
Ready on Perkins, Randy?
Yes. I don't know these up yet.
Huh?
They're bringing the book.
Okay. All right, we don't see a defense attorney here.
I'm what?
Jones?
We don't see
He's
Catherine.
down going over the PSI with him.
Oh, all right. Thank you.
Okay, on this little corner right here.
I take no problem out of it.
Probably not. Oh, wow.
That's what I was thinking. You're next. Here's this big.
Or do you need that back?
No, I already, there's a copy in there, so you keep that one. Let's
Got it.
Good to go. Perfect.
Mr. Blackman, did you need another minute?
No, we're good.
Okay, all right. This is docket 23-358 FH and 25-5598 FH. People of the state of Michigan versus Mohammed Idris Perkins. Counsel?
Thank you, Your Honor. Randall Berman on behalf of the people.
Yeah, I'm Fred Blackman on behalf of Mr. Perkins. He's standing to my right at podium. Judge, we have already completed the pretrial form and set dates for final pretrial and trial. Today, I'm here for bond reduction motion on behalf of my client. There is also a probation violation that I'm not on, but the public defender will be handling that. But bootstrap probably my arguments concerning
Okay.
If I may, Your Honor. Yeah, thank you. Attorney Aaron Schroeder on behalf of Mr. Perkins for the 23-358 FH file that is also set today at the same time for the probation violation. Mr. Blackman is correct. I would be joining on the request for the bond modification. I was here with Mr. Perkins back on the 22nd of September of this year. And there was a bond that was put in place by the court, $100,000 cash bond, and to his probation file. The probation violations are, with the exception, I believe, of one technical violation directly related to Mr. Blackman's file, which is why I believe it is appropriate. Thank you.
Mr. Tyndall is here on behalf of probation. I'm looking, what's the date of the bench warrant? The one I have is August 28th. Is there a new one?
No, Your Honor.
That's the one?
Yes, Your Honor.
Okay. So is that the one you've reviewed with your client?
With regard to probation violation, Your Honor? Yes, I previously reviewed it with him. We set this originally without date because of the fact it was the case that Mr. Blackman's on was still in the 55th district pending.
All right, thank you. Sir, please raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
You have been down by hand. Have you had a chance to talk to both of your attorneys?
Yes.
Have you taken any medication yesterday or today?
No, ma'am.
Is there medication you're supposed to be on that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And, sir, I have allegations of violation of probation. And you were on probation for the following. Weapons carrying concealed with habitual third, that's punishable by 10 years, and possession of a controlled substance known as cocaine less than 25 grams with habitual third, that's punishable by 8 years. You recall that?
Yes, Your Honor.
All right. And the violations are as follows. As to count 1, on or about August 21st, 2025, defendant possessed a handgun. As to count 2, on or about August 21st, 2025, defendant knowingly possessed handgun and ammunition. Count 3, on or about August 21st, defendant possessed cocaine. Count 4, on or about August 21st, 2025, defendant maintained a drug house. And then count 6, on or about August 21st, 2025, defendant failed to report a change of residence as directed. I think the only thing we can proceed on would be count 6.
I would think, well, on my paperwork, Your Honor, it is listed as count 5.
I'm sorry. Oh, yeah, sorry, count 5.
But yes, I would say yes, Your Honor, at this point, but I don't know. As I don't have the underlying file, given the fact that it's on the same date as the others, I'm not entirely positive as to, as to its impact on the others, I guess the best way to put it, because I don't have that access.
We can hold it, all of it in advance, doesn't matter to me. Are you waiting for the arraignment?
I would, Your Honor, and I, as I indicated a moment ago, I think we were here on the 22nd, and I thought he was arraigned on that date, because I did make a bond motion the 22nd of September. But
And he may have been, I don't know. And,
absolutely, Your Honor. But yes, at this point, I would hold off on it because I know that Mr. Blackman's files, which is, I believe these all stem from, based on the date.
And he may have been arraigned, because I have notes that say, that it doesn't hurt to do it a second time.
Certainly.
That this should travel with this other file, Mr. Blackman's file.
Yes.
And I had at that time given him 100,000 cash bond with GPS tether.
So that would be my continuing request, Your Honor, my apologies.
For bond?
Well, not with regard to bond, with regard to it just traveling along with Mr. Blackman's given the connected.
That's what will happen. So what are we doing here today?
I can do a bond motion.
Yeah, we'll switch in.
Okay.
We filed a reduction of required 100,000 cash security bond good. We had pretrial services do a report. We've been in receipt of that, Judge, and I've gone through that. I'm not going to highlight what I did in my written motion, but I just want to point to a couple of things. When the additional considerations in this report that were prepared for the court and for us, there's 4 things they talk about it. He's before the court, not a non-violent felony offense. His address and employment have been verified. He's been and they go to the third one, twice convicted of a felony, therefore he doesn't receive any of the benefits. If he had to put a tether on, he would have to pay for it himself. That's basically what it sounds like to me. And he's under current supervision of Agent Tyndall. The other things I want to talk about is in the courtroom today, Judge, is his brother and his mother. They're seated back in the audience. They talk about his prior employment with Amazon and also the lawn service. His brother owns the lawn service, and he works for him as well as Amazon before he went into jail. He is born and raised in this area. He has plenty of friends in this area. He also has never had a failure to appear in court. That's good and bad. He's had other problems, but he's always showed up for them. And right now, both of his brother and his mother would vouch for him. What they're asking the court is the court will consider reducing the bond based upon the factors that they outline there, knowing that he cannot have a PR bond based upon the factors and the considerations in there. But we'd ask for a reasonable 10% bond in this matter with tether. I'd like to get him back to work. When I talked to him, we're trying to work out this case. There's been a plea offer in the case, and we have not accepted any offer at this point. We do have coming up final pre-trial and trial first part of next year. So I'd ask the court to take all that in consideration, especially a report. Also, the court wanted to address his mother or his brother about what would happen to him if he's out. He's living with his mother on Averill Street. So that's the address that's been verified on behalf of him. So I'd ask the court to take that into consideration. Thank you.
Mr. Tyndall.
Thank you, Your Honor. This person was doing very well in probation prior to this. Your Honor, he was attending treatment, he was drug testing. I think the issue that we have with probation is every time we met with him, the standard question we asked you is, have you changed your address? And he would say no. So when we found out that he was living at another address, which is where any charges occurred, it was just kind of alarming to us that he was telling us he was living in one place and he wasn't actually living there. So he was doing well on probation in one aspect, on the other aspect, he was hiding some things from us, Your Honor. So that's concerning for us, but I would.
Did he complete anything on probation?
He was attending CMH, he was drug testing clean, so he didn't complete anything yet. He was in the process of completing his CBT at CMH. I tried to contact his CMH worker to verify his progress as far as how close he was. Haven't received anything back from that yet.
On behalf of the people?
Thank you, Your Honor. As I see it, the defendant has 2 files. They each have $100,000 cash surety bond set by the court. I just, not to belittle Mr. Tyndale, but I dispute the fact that he did well on probation when we have a new file with 7 charges, a half fourth, all involving weapons and 1 count involving another drug charge. His other case that he's on probation for had 9 counts, and I had mercy, and he pled to a couple of those to give him a shot in the community, and here we are. I dispute the fact from what Mr. Blackman said that he's shown up to all of his court dates. The pretrial service bond report indicates that he has 2 or more qualifying failure to appears. They do not recommend, nor do they say he's even eligible for a PR bond. So this court has to set some form of a money bond. So as far as I'm concerned, I'll leave that to the discretion of the court. I just would object to and do not support a PR bond. I think, quite honestly, the bonds are set properly because the defendant was given a chance. He was on probation, failed to tell probation where he was, and lo and behold, there's a search warrant based on probable cause for the residence that he's at, and now we have all these new charges that again involve firearms. So it is concerning to the people, Your Honor, and so I would submit to the court that his bonds are set at the proper amount and form. Thank you.
Without talking about the new allegations, what would you like me to know, if anything, sir?
Oh, well, one thing I noticed that you asked on there is if I completed anything on probation. I have completed the 90 and 90, which was set by you, which is every day for 90 days to go to a class. And if I was to miss one, I would have to start over. I didn't miss one. I actually got that done in the 90 days. I was fairly almost done with the CMH that you had sent me to go to as well. So I did complete some things that was on probation that you had sent for me to do. I think the only thing pretty much I didn't do without the new violations, of course, was the money that you had set for me to pay. With that, that would be all I would address.
Judge, if I might just add 2 things. He's been in jail since August 21st, as of today. In addition to that, Judge, I understand position when I've gone through this all the years I have. There are allegations at this point. He's pled not guilty to them, so I'd ask the court to take that into consideration too.
The court also has to take into consideration the safety of the public, and I would agree, Mr. Tyndall, that he's done well at the 90-90 and mental health, all of that. A lot of people never get that far. But I also agree with the people that he's done a cracking job because now I have multiple files. And the allegations are ones that are concerning and pose a danger to the public. The maintaining a drug house is harmful to the community. And although it's innocent until proven guilty beyond a reasonable doubt, I have different considerations for bond. And that one of them is what I consider a high priority and incentive as to my decision-making, which is public safety. So we have handguns and we have cocaine and maintaining a drug house. So the community is not safe. And although you have gone to AANA for the 90 and 90, which is impressive, something isn't registering because I have new drug charges here. And you're giving drugs allegedly to the community. So maybe you want to stay clean, but have others help them get dirty. I don't know. What I have to do is look at public safety. When I look at all this combined, I'm sorry, counsel, your motion in both files is denied. It's remaining as is.
Thank you, John.
Thank you.
I'll probably, would you call like for further on?
I don't know that we need, I think that,
They're doing
I don't think we need the order. I guess. Yeah. If you want one order, we can just write it down if you want, otherwise we're. good.
Okay, Judge, that's fine. Thank you.
Thank you. Good night.
Fred, if you hang tight real quick, I'll get you that form. No, I'm in the pre-trial form. Yeah.
Who's next?
We're ready on Jones.
Okay, okay.
You have, is that everything? All right, let's say this is where.
You can.
Sorry. I wasn't-
No,
No, I don't care.
it's actually small. Yeah.
We're gonna.
You're not done words. Natalie,
Yes.
what's the word?
What's the word on order?
What's the word on order?
Off the record, we're getting a new date. He's waiting on screening for a Veterans Board.
Oh, okay. Oh, I'm sorry. Yes. Don't need to get it.
I get it.
But that's what's the battle probably needs to cross down to the veteran too.
This is the docket. Twenty-five, 3-1-5-7 SC, people of the state of Michigan versus Aaron Abram Jones II. Counsel, your appearance for this from the record.
Good morning, good morning, Your Honor. Angela Delvero on behalf of the people.
Good morning, Your Honor. Jeffrey Kaplan, P74943, on behalf of the defendant who's standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, full truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Raise your hand, and you don't have to lean over it. Just the microphone's strong enough to pick you up, otherwise, I'll tell you to speak up. I think we're good. All right, we're gonna get a show break doing that. All right, very good. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you've had enough time to speak with Mr. Kaplan?
Yes.
And you pled guilty to criminal sexual conduct first degree relationship, punishable back to life. Do you recall that?
Yes, Your Honor.
And have you had an opportunity to review the pre-sentence investigation report with your attorney?
Yes, Your Honor.
Thank you. Any corrections, additions, deletions on behalf of the people?
Judge, on the face page, it shows in the box at the top, it says final charges, charge 1. That should be charge 4. He pled to count 4.
Thank you. Anything else?
That same correction probably should be made on the guideline sheet, which I think says 1 of 4. Oh, it says 4 of 1. I guess it should just say conviction count 4.
And 401 is weird.
Yeah.
Okay, I've done that. No objection, counsel.
No objection.
All right, anything else?
I have no other no additional corrections, deletions or modifications.
On behalf of defendant?
The only thing we would note, Your Honor, under the substance abuse treatment, that would be on page 12.
Yes.
In the box where it says treatment type, the line that begins with AANA.
Yes. Self-help.
Yes, he tells me that he did complete that. So that should say yes. I have not verified that. I believe he tells me he was in jail. I don't know if the prosecutor's got other information.
I'll leave it to the court's discretion.
So here's what it says. So I think what's more accurate, it says the defendant reported that he attended AA in approximately 2003 and that he completed CAT substance abuse treatment during his current incarceration at Ingham County Jail.
That would be the first line.
So okay.
Yeah.
Oh, I got it. Okay. So, sir, was that part of a court order or what was that?
Yes, ma'am. It was for probation.
And so that was, did you successfully complete that probation?
Yes, ma'am.
Okay. I'm simply going to add in the narrative on probation. Which he completed successfully. And then under completed, where it says no, but yes, because I think the thought there probably was that you read, when you need to go to AA, NACA, and just never really complete that, it's an ongoing thing. So I think if he's completed it as a probation condition, it's completed.
Thank you.
That makes sense to me. Is that agreeable with the people?
That's perfectly fine.
All right, thank you. Any other correction, addition, deletion?
Not for the defense, Your Honor.
And on behalf of the people, the guidelines?
The people have no corrections to the guidelines.
Counsel?
Defense does not have any corrections to the guidelines.
All right, thank you. And do we have a victim who wishes to address the court?
We do, Your Honor. Both Amelia Jones and Annika Jones are present and would like to address the court. They also prepared written victim impact statements, Your Honor, that they'll be reading from. May I approach and ask the court to attach these to the pre-sentence report?
Yes. Any objection to attaching them?
No, Your Honor.
They'll be attached. All right. Please approach. You can come up separately or together.
I think they're both going to come together and they'd like to sit at the council table if that's all right with the court.
All right. Please raise your right hands. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. And counsel, if and have a seat, and counsel, could you just move the microphone closer to them? They're a little soft spoken. And could you please state and spell your name for the record?
My name is Amelia Jones, Amelia Jones.
My name is Annika Jones, Annika.
Thank you. Who would like to begin? All right, thank you. I know you're reading this, but read it like you're reading to a 5-year-old. Because the court party needs to get everything down. Sometimes when people read, they read really fast just to get it over with, but we can just the steady pace would be good, okay?
Okay.
And if you need to take a break, let me know. It's fine.
Thank you. sorry.
It's okay. Take your time.
As I sit here and read this, I can't help but have so much fear for this world. Fear because you never know the evil that lurks right in your own home. The place that is supposed to be your sanctuary and peace, let alone in the rest of the world. I have always fought to protect my children. To keep them safe from people exactly like him. I would never in a million years thought he would have been capable of this kind of evil. Aaron was the person I thought would finally be the father my children needed. The one who stepped up when their biological father chose to step down. I trusted him with my life, with their life, with everything. I built a family with this man for over 13 years. I let him legally adopt my children. And little did I know, behind the mask was the worst kind of evil. An evil that set out to ruin a little girl's life. Honestly, it almost did. It caused her to want to take her own life. And I always wondered why my baby girl was always depressed, sad, and even suicidal at times. I have had her in therapy from a young age and spent many nights crying to him about why would my girl feel like this. To me, she had a great loving home with everything she ever needed. Little did I know that she was experiencing the worst kind of hell for so many years and I had no clue. It's hard to not beat myself up for not knowing sooner, but this just shows how evil this man is. To be able to do the monstrous things he has done and put on a mask so normal, like he had zero remorse, all while watching her suffer mentally. While watching me suffer mentally, trying to figure out what was wrong with her. I will no longer beat myself up because I know that I never did anything. It was all him. I was blindsided completely. The second I found out, I ended everything because there's nothing on this earth that would stop me from protecting my children. Thinking back to April 10th, 2025, the day the truth finally came out, is a pain I would never wish on my worst enemy. I spent many sleepless nights crying my eyes out in so much pain, while wondering how something like this could happen in my own home. But why us? Why? Why? Truth is, evil is everywhere, and all we can do from here is heal and keep moving forward. I refuse to let this man have that type of power. He will not break our family. God is behind us in each and every moment. The devil will not win, and he will not have my children. I am beyond proud of my daughter for being brave enough to speak her truth. She is one of the strongest people I will ever know. I am proud of myself for picking up the shattered pieces he left in his wake, for finding myself again, and for my resilience. I am proud of all of my other children for being so very strong during this, for not letting him ruin what's left of their childhood. I pray that together, we can face any trauma that may linger through the years to come. They all lost their father in the blink of an eye. He shattered our world, and he did it slow and intentionally. We will never be the same. We will always carry this experience with us through life, and I'm not sure if the pain will ever truly go away. Each and every one of us is a victim to his twisted, sick mind, none more than my daughter. But what brings me peace is that I know God has a plan for each and every one of my children, as well as for myself. I pray that Aaron finds the help that he needs to face his demons. I pray that no other little girl ever has to suffer at his hands. I pray that someday God can bring me to complete forgiveness, not for him, but for myself. I pray that today justice is served, and someday eternal justice will be served. It is not for me to be judge and jury. I leave that in God's hands. Just know that even though my family has gone through a tremendous amount of pain and suffering, we will be all right.
I'm sure you will. It takes a lot of bravery to come forward and face him. It takes a lot of bravery. And a lot of parents I see do not choose their child over the predator, they choose the predator. It's just something that we see all the time. And so you are a hero and a wonderful example for your community and for your children to choose your child immediately and walk away from this long time relationship that you trusted. So that is really a sign that, yeah, you won't be the same. Nothing will ever be the same, but you'll be stronger together. And speaking your truth is really powerful because this crime is one of power and control. And you have taken away his power and control. And that's really, really important to healing as a family and with your daughter. And I applaud you for being here today and talking publicly about this. It's not an easy thing. So you have just chosen the absolute highest right ground, and you did nothing wrong. You did everything right, especially coming to court, because you're also not just protecting your family, but all those others who may have or will come in contact with them. So thank you for being here.
Thank you.
What would you like me to know? Take your time.
Two 237 days since the last time I seen you. 33.5 weeks to think about all the things that I wanted to say. Your actions took a piece away of my life that I can't get back, and I have spent years trying to understand why someone who was supposed to protect me chose to destroy me and break me down for so long. I no longer look for answers. I no longer expect you to understand the damage you caused. Whether you grasp it or not, it does not matter. It has changed nothing for me. There is a piece of me that believes that you never thought this day was coming. You thought I'd always keep quiet and keep to myself and let the weight of it rest on my shoulders. You would shame me for the same things and shame me and other people for the same things you did. You made me feel like my body was the only thing I would get through the world through. My mindset so young, of 11 years old, of the mental that someone had to see my body as attractive to see that I am something. I have always been something, just took a lot of time for me to realize that, and still more growing till this day. I have so many things I want to say and can say, but I'm going to keep it short and deep. Was it worth it? Did you ever look at me as I was your daughter? The years of damaging my mind and self-respect. And I feel like a lot of people question why I didn't say anything sooner, and why I waited so long. But I felt like I kept quiet because I love the idea of having a father, someone to protect me, someone to have my back, let alone a father in general. But I chose to stay silent for my family, for my brothers and my sister, and most of all, my mother, the woman I thought you loved and cared for. I couldn't imagine the pain it would bring her until one day I broke the silence, because she was no longer happy, and there was no longer a reason to keep myself shut down in a box for the rest of my life. The day I told my mother what happened, I felt sicker than I've ever felt before, because it didn't feel real. The words coming out of my mouth felt like a nightmare coming to life. But 237 days later, I can finally taste a bit of freedom. The freedom of not having that on my shoulders to think about every day, constantly, and having to make eye contact with you, knowing the things that had happened behind closed doors. I could have been shown innocence. I could have been shown what a real father is supposed to do.
You are brave. Do you know how brave you are? Statistically, there are very few people who come forward. And sadly, this happens too often. And your bravery saves not just you, but what could be hundreds of girls. I don't know that he would attack hundreds of girls, but every day, hundreds of girls are attacked. And for those little girls to know that there's hope, that they will be heard and believed, is a gift. So I know you don't look at this as a silver lining, but part of the silver lining is your strength. And then you and your mother, of course, was your biggest champion, but you championed yourself. You were your own superhero. You were the voice that rose, that said no more. And that takes guts, and that takes strength. And that takes a lot of inner power and resilience that you probably did not know you had until it was coming out of your mouth. And the great thing is, so many kids are not believed, and your mom immediately believed you, and you too became a powerhouse of strength against someone who should never have touched you, never wronged you, and who you willfully entered into your home because you trusted him, and the trust was broken. Neither one of you did anything wrong, and you didn't do anything wrong by waiting long to tell. Most people do wait long. They are threatened. They are worried as you cared about your family more than you cared about yourself at that time. You're trying to protect everyone. That's a heavy burden, and I am so proud of you for releasing that burden to your mom. Many people never get the chance. And it just tells me that you have a really strong family, and you knew that they would help lift you up. So I'm really honored that you came here to testify and to tell me exactly how you felt and what you did. So from this day forward, you leave your pain here and you go out in the world and you do magnificent things because you are certainly capable, and you have shown that by coming forward. Stronger than most.
Thank you.
Is there any restitution that's being sought for counseling or other?
There is, Your Honor, and it's recommended in the pre-sentence report, and it's also recommended as condition 1.
Okay, so that was $2,480, but is that ongoing, or what would you like me to do with that?
Just what you,
That's just what we've incurred in therapy,
thus far.
Okay, so I'm going to leave it open. And is that really the primary bill that you have? Other hospital bills or other
There's a million bills.
related to this?
I guess that's it.
So related to her injury.
Okay, no hospital bills, pretty much just the therapy bills right now. We have a copay, so that's all added up. So currently, that's what the copays have been since this occurred.
Okay, and so have you divorced him? Okay, and has he been ordered to pay anything?
No.
And
I think he's released parental rights.
yeah, I was gonna ask,
Yeah.
you released parental
He
rights?
has released his parental rights voluntarily.
Okay, so there's no, do you have any of his things? Is there anything else that we need to resolve?
No, I think everything was resolved within the divorce. I obviously can't get much with him being gone. So I think that we came to a reasonable agreement during the divorce as far as like what is actually feasible.
And has he tried to contact anyone?
Not at all.
Right, I'm going to keep that no contact in order or in place, and then you let us know if he does contact anyone. Is that all right with you? Okay. On behalf of the people, anything you want me to know?
Your Honor, what I would indicate to the court is that there is a sentence agreement in this particular case of 20 years on the minimum. I would note that the probation department did not recommend that on the minimum.
I noticed that it'll be the 20 years.
I think they're bound by the guidelines. I understand that by policy. I would indicate to the court that 20 years is above the sentencing guidelines, but to make a record, I suppose I'm not really reminding the court, but to make a record, that is indeed less than what he would have received had he been convicted as charged, given that He was charged originally with multiple counts that involved a 25-year mandatory minimum. And additionally, what I would indicate to the court for the record is that I think it is reasonable for the court to exceed the guidelines and to follow the sentence agreement, not only because it was agreed upon and it is not a illusory plea offer, but also because these sentencing guidelines don't have any ability to take into consideration the number of times that Annika was victimized by her adoptive father. The defendant's own statement is that between the ages of 12 to 16, that he engaged in sexual assaults with her on a monthly and sometimes weekly basis. There just isn't any way to count those in the sentencing guidelines. So I think this is a reasonable sentence. I think that that is a basis that 20 years is proportionate. And I'd ask the court to follow the sentence agreement of 20 years on the minimum. The probation department has also only recommended 30 years on the max. I'm asking the court to consider a much higher max than that. To order the current restitution and then leave any balance open. And if there is an additional request from Mrs. Jones, from Amelia, I will file a motion to add to that amount. And I'm asking the court to add a no contact provision with Amelia Jones and any of her children. As you have already indicated, Annika was incredibly brave to come forward. Her statement is so heartbreaking and yet so typical. I don't know if that makes her feel better or worse, that her response to being sexually assaulted by her adoptive father, what is her response? To protect her mother and not come forward right away. That is unfortunately so common and just shows sort of like the open-heartedness of children, that they'll consider everyone else but themselves in order to protect what they believe is their family unit. And that's why these types of crimes are so egregious, because offenders take advantage of that open-heartedness of children, that generosity of children to allow themselves to continue to be victimized if it means that their mom is happy, if it means that their brothers and sisters still have their dad. And that's why I think the defendant is deserving of the sentence.
Counsel, what would you like me to know?
Thank you, Your Honor. Typically, when there is a sentence agreement in place, I usually don't say much, but considering the maximum here is still open for determination, Your Honor, just considering the seriousness of the crime, I feel obligated to say a little more here. And first, I want to point out that my client, when he was finally confronted with this, admitted to everything. That's why the case couldn't go, it just wasn't a triable case. He didn't try to make excuses. He admitted everything to his wife initially. When she questioned him about it, he didn't try to hide it, make excuses. He admitted everything to the police, didn't try to hide it or make excuses. Unfortunately, Your Honor, he loves his kids. I know that. He's expressed that in the text messages with his wife, his now ex-wife, after he was exposed. And I'm sure he loves his wife. The one thing that is not present in any of these police reports or the PSI is that he was physically abusive or emotionally abusive to anybody. And I know the argument is, how can you hurt somebody that you claim to love? And I think that's because this is the crime of impulse. I can't explain why clients always do what they do, but I know the sexual attraction, the need for sex is impulse. In this case, he developed an emotional attraction to his stepdaughter. You know, why? I wish I could understand, wish I could explain it. But the other thing that is not present here is that he was been trolling the internet, looking for other young girls or boys for that matter. This was an emotional thing with her that he let blossom into something that was inappropriate. And by talking to him, he's embarrassed by it and even ashamed of it. Because everybody else certainly knows about it now, his coworkers, his family, his friends. And unfortunately, he succumbed to a temptation that he shouldn't have. And the unfortunate thing is everything else in his life seemed to be going the way it should. And he seemed to be doing everything we want a productive member of society to do. While he had troubles as a kid and was expelled from school in the 10th grade, he joined the military and served in the National Guard for 4 years. And then he furthered his education and became a member of the plumbing union and was a pipe fitter and was making good money and supporting the family and trying to do right, except for this issue with Annika and the sexual abuse. It's also notable that the PSI indicates that he admitted that he was sexually and physically abused himself as a child. And one of the things we know about sexual and physical abuse is it tends to manifest itself in successive generations. And maybe there's some underpinnings of that and that led to his relationship with Annika. The point of all this, Your Honor, is to say that I think my client is salvageable. I think he's redeemable. He was willing to accept the 20 years. And I've got a lot of clients, Your Honor, as you can imagine, make a lot of excuses for why they do what they do. And that's not been my experience with my client. He acknowledged from the beginning that there's no excuse for this. He did not want to go through a trial. He does not want to drag Annika through testifying, or Amelia for that matter. He wanted to get this over with. Of course, he doesn't want to go to prison, but he was willing to accept that as the compromise. But again, this was not a very triable case because he acknowledged the wrongdoing once it was exposed. Didn't make any excuses, never made any excuses with me. All that is to say, Your Honor, the maximum sentence under the Tanner rule that you can give him is 30 years. I certainly think he needs to address any of his own abuse that he experienced in his life in therapy. I don't think that he's shown that he is a danger to the general public, considering that there's no indication that he's trolling for other underage children. This is an issue that was specific to Annika. I think that in terms of punishment, 20 years is satisfactory. I think in terms of rehabilitation, Your Honor, 30 years on the maximum is certainly enough time for him to address these issues, do whatever programming he needs to do, and become a productive member of society on his release.
Thank you, counsel. Sir, what would you like me to know?
Well, I appreciate everything that my lawyer just said. I know at the end of the day, there's no excuse for any of my actions. I pray every day, and I'm not for myself. I pray that my children find healing, and that I hope they do know that I do love them. And they were my everything. They're still my everything. There's no amount of apology I can give that would ever suffice. I hate myself for what I did. And I hope that one day they can learn not to hate me for what I did.
Judge, just for the record, this is a life offense, so the Tanner case doesn't apply.
Sir, if they were your everything, you would have protected them. You would not have abused your daughter. And by the way, she's no longer your daughter. Those children are no longer related to you.
In my heart, Your Honor, they'll always be my children.
And in their hearts, they're always gonna ask, why did you do this? And they're never gonna have a proper answer. And they don't see you as a father. You have erased all of that. You are their demon now. So you feel what you need to. No one has control over that. But they are erasing you with good reason. Love is kind. Love is not abusive. Love does not have a father taking sexual acts, having intercourse with their minor child or any child.
Yes, Your Honor.
Doesn't matter that you were related by adoption. Once you do that, you are family like blood. They are your own. And you abuse that relationship. And you use power and control over a child who did not have a voice. And in the end, she does have a voice, but it took her a long time to find that because she's confused, because you've taken her voice from her, because she's trying to protect those she loves, who you did not love.
I love my children, Your Honor. I still love my children.
Now, we can debate that all day long. And as I said, you can feel how you want to. But you're gonna have a long time in prison to figure out that that is not love. We do not show love with sex. Sex is a function of a body, and you abuse that with another human being that you have power and control over.
Yes, Your Honor.
So I hope that you have some time to reflect in prison, that that is not love. Now, your attorney told me that you had also been abused, so that statement does not surprise me. So I will order that you in prison comply with SORA and the Sex Offender Registration Act, and you'll learn all about that. But that you also receive treatment in prison for being an abuser and a victim. Because victims tend to think that that is love, and it is not love. Just like people are beaten up, think that they must be beaten up to feel love. It's not love. You are confused, sir. Sadly, a little girl paid the price of your confusion. You knew better.
Yes, Your Honor.
And your attorney tells me you served in the Michigan Army National Guard. So did I, but you forgot some lessons. Duty, honor, country, family, protect, and defend. You forgot all of that. So it does not impress me. In fact, it saddens me that you were one of us and you didn't honor what you learned, what our duty is, the oath that you took. You defiled that service as well. As to count 4, you are remanded to the Michigan Department of Corrections for a period of 20 years. That's 240 months to 50 years. That's 600 months. You have credit for 202 days that you've already served. You'll pay restitution in the amount of $2,480, which is payable to Amelia Jones. And that amount will remain open because the victim is still in treatment. So whether it's the co-pays for her continued counseling or any hospitalizations or any related matters, you are going to pay. I'm also going to have you pay for a copy of the sentencing transcript And if the victim wants and their mother wants a copy of the plea transcript, and that is going to be turned over to the mother, who will keep that and give it to the therapist if needed for treatment. Because I think it's important that the therapist help her understand what happened, the words she said, the support she had from her family, and all of that. And I don't know what remains with her, because trauma lives in the body, and she needs to understand and have people understand. And she'll have triggers now throughout her life. And so one of the best things that can help her is this transcript. And it goes away after several years. So there's no way to get it back. So I want it now. So during her life, as she needs treatment, her providers will know what happened.
Yes, sir.
And that's at your expense. And I'm making that part of restitution. It's an important part. You will pay crime victims assessment in the amount of $130 and waiving fines and costs, finding that you're indigent, you'll pay a $68 state cost. The restitution will be paid before any crime victims or state costs. And the crime victims assessment and the state costs can be held until his release. The state can wait for that. I want the restitution paid first. He's not to have any contact with the victim or siblings, his ex-wife or the related family, and no contact through third parties. Don't get creative, no Hallmark cards, no carrier pigeon messages, no smoke signals, no messages through friends or decoder rings. Don't get creative, because I call the warden. And then you want to have contact with anybody unless they come to visit you. Before you release, you certainly will become familiar with SORA a lifetime. And I believe it's lifetime tether, is that correct?
Lifetime electronic monitoring, yes.
Yeah. So you'll have to become familiar with all of the requirements in where that lifetime tether. Understand that, sir?
Yes, ma'am.
If you're fortunate enough to go to a facility that has some animal therapy, I would ask that you be part of that, because animals love unconditionally. And somehow you haven't learned that in your life. So there's a really good program that seems to help people. But there are too few of them, so I don't know where you're going at. You have 42 days to appeal to request appellate counsel. Please hand this appellate rights. Is there anything I failed to address on behalf of the people?
Nothing, Your Honor.
Is there anything I failed to address?
Not for defense. Your Honor.
Do you acknowledge receiving your appellate rights? Oh, you know what, let me just quickly add this. I know I went over guidelines, but I do believe this properly addresses punishment of defendant and his rehabilitation. Clearly, this was not a one-time thing, this was over a period of time, and it was with a very young child, one he was related to, who claims to love. I think this speaks to rehabilitation, the length of time he's gonna need to rehabilitate himself and to turn to others, and protection of society without this lengthy term of treatment behind bars. Because it went on for so long, so many times with his own family, I believe that there is a potential without this lengthy stay, that this could be a problem to others in society, regardless of your embarrassment. As your attorney says, it does become an impulse, often that you can't control. And so you need this lengthy treatment to protect society. I believe the sentence is reasonable and proportional given the circumstances here. Anything else?
Thank you for remembering to make that record as it relates to the guidelines, Your Honor. I had forgotten. Just
Yeah.
we're also adopt the arguments that I've made as
Yes.
really exceeding the guidelines.
Yes, I do adopt what you said, and I think that the pre-sentence investigation report is a good job too.
On my part, Your Honor, I am not objecting to exceeding the guidelines because as part of the plea deal, it takes a 25 years mandatory minimum off the table. So that's the compromise there.
Yes, thank you for noting that. I
Absolutely.
did see that as well. Thank you. That's all for the record. Your man is served.
That's one, right? Yeah, that's one, right? Rob's got to come up here to- My client was in the military too. What can you bring Duncan, please? Yeah. Downstairs. Yep, I got one. That's why.
All right, we have, Duncan.
Yeah, Judge, this is a bench warrant arraignment for his failure to appear. Ms. Maycomer and I have kind of worked out this like twofold plea offer where he can pick one or the other. It's like a choose your own adventure. He's not gonna do it today, but we're gonna can we set it for like, I know you said that your December is jammed, but can we set it for pretty quick back? He did turn himself in on this, on his bench warrant, so he's gonna admit he missed court, and then I'm gonna argue bond. I don't know what
And
she
he
could,
didn't just miss, he lied to us. Someone called stating he was in the community mental health crisis unit, but then there was a previous bench warrant, so we didn't do anything, but I think that we found out, I think this might be the one that we found out he was not in, or he didn't provide proof of that.
I didn't know that, I haven't heard that.
I just.
Part of the problem, to be perfectly honest with you, part of the problem was that I had great contact with this guy. He never missed anything. Everything was going great. And then I went on FMLA and somehow it just turned into a train wreck while I was gone.
Sure.
Like,
It's your fault.
I know, right? Like,
I'll do anything.
I'll own it.
Clearly should.
So I don't know what went wrong there. Like, I just don't know. But like, I thought he's been doing well.
Yeah.
So I'm
sure he'll tell us.
gonna ask you to let him out today. I don't know whether you will or not, but.
I don't know if I will or not. I guess I'll wait to hear.
You know, we should all be in the Christmas spirit.
Yes, but the Grinch does appear now and then,
Yeah, Judge, you don't want to be the Grinch.
I don't know, like green color looks good on me.
He's kind of a really popular character.
You can grab it, bro. Stand on this side. I think they want, you want them on this side. Yeah.
This is docket 24689 FH, People of the State of Michigan versus Joshi Vermont Duncan. Counsel, your appearance for the record.
Good afternoon, Your Honor. Natalie Maycomber on behalf of the people.
And good afternoon, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Duncan, who stands to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
And you may put your hand down. Sir, have you taken any medication yesterday or today?
No.
And is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had a chance to talk with your attorney?
Yes, ma'am.
All right, thank you, sir. Sir, we are here on a warrant that states you should be held in contempt for failure to appear, and that would be for a pretrial on October 8th, 2025. Previously, and I just want to note for the record, I have a note in my file, and I think we simply rescheduled this. Someone, it states someone called stating he was in mental health crisis unit, and that was on June 11th, 2025. And I think then we rescheduled it for this October date, and then you failed to appear.
Yes.
Are you waiting for further arraignment?
Yes, Your Honor.
Will this be a plea or a hearing?
This will be a plea to the missing court, Judge.
Is that correct, sir?
Yes.
And so as to failure to appear for pretrial October 8th, 2025, how do you plead? Guilty?
Yes, that's what you.
And did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything that caused you to plead?
No.
You understood you were to appear each and every time for a hearing, and you failed to appear for that pretrial?
Yes, ma'am.
Okay. And sir, you pled of your own free will?
So what now?
You pled of your own free will, no one forced you?
No.
So that's yes, you pled of your own free will?
Yes, yes.
After you consulted with your attorney?
Yes. I'm
And-
sorry. I
It's okay.
misunderstood.
No, that's okay. I just made sure the record, I knew what you meant. It's just the record wouldn't read it.
Yeah.
Right, so.
I was a little confused. I'm
It's
sorry.
okay. No, you're good. And you chose to plead after you consulted with your attorney,
Yes, ma'am.
and you were satisfied with the representation of your attorney?
Yes, ma'am.
You are held in contempt for failure to appear for pretrial based on preponderance of the evidence you've admitted to it. And that was a pretrial on October 8th, 2025. May we go into sentencing?
Yes, Your Honor.
Yes, Your Honor.
And on behalf of the people, what would you like me to know?
Thank you, Your Honor. Your Honor, based on the circumstances surrounding Mr. Duncan's failure to appear, I would just ask the court, if the court is going to reinstate bond, if the court is going to sentence him to any sort of jail sentence, then it be time served. If the court is going to reinstate bond, and put it in tether in place.
All right. Counsel? What would you like me to know?
Thank you, Your Honor. I'm also asking the court reinstate bond and release Mr. Duncan today. There's a couple of things that I just want to make a record of. He's admitted to missing the pretrial hearing on October 8th, and there's no question, I was here, he was not. There's no question that occurred. I do think that there's a little bit of a question as to whether he had ever had notice of the October 8th date. I think I raised that in October. I just want to, this is not really justification, but I want to be clear about some things that have happened here. Mr. Duncan and I were in great communication for the entirety of this case. I went on FMLA in late spring, early summer of this year. I was out for a couple of months. And when I went on FMLA, things fell apart. And I don't really have a perfect explanation for why that is, but it just fell apart. And I'm not sure, I trust my coworkers, but I'm not sure that they were getting him notice. It's hard to decipher everything from the notes. Things kind of went sideways. The point is, I think we are back on track. I work very well with Mr. Duncan. I have no problems with him whatsoever. And I think he would agree that we work well together.
Yes, I have never missed none of your court dates. I have been there. When he went out, I was trying to contact him, and it was like here and there because Leo Bill's bondsman was trying to contact me to contact him, and I couldn't get a hold of him.
I would also point out that my understanding is he turned himself in on this matter when he realized he had the warrant, which I advised him of once I was able to get in touch with him. He's been doing well on bond. I think this is the first bond violation hearing we've had. I think he's working well with pretrial services, all of these things. We are also very, very close to a resolution in this case. I anticipate that we'll have that worked out. I'm also going to ask the court to set a plea date or pretrial or however the court wants to do it. But I'm going to ask the court to set back a date here pretty quick so that we can get this resolved. There's a couple, Ms. Maycomber and I engaged in, I think, fruitful discussion today about resolving this case. She's given him 2 different plea options, and Mr. Duncan is in the process of choosing one of those. Part of the issue is I want to verify guidelines before I can make a fair recommendation. I want him to be fully advised. So with all that, Judge, I'm asking that the court set this out. I think that we'll get this back on track and resolved pretty quick.
Thank you. Sir, what would you like me to know?
If you want to say anything.
You don't have to.
No.
Okay, so, are you still living on 824 Buffalo?
Yes, ma'am, I am.
And who do you live with?
I live with my aunt.
Okay, and are you working? What are you doing these days?
I'm actually taking care of my aunt. She had a stroke.
Okay,
I'm kind of her care provider. She can lift over 10 pounds.
okay,
So I'm cutting the grass, shoveling, whatever I gotta do to help her.
okay, you getting paid for that?
Huh?
Are you getting paid for that?
No.
Okay.
It's like more like my aunt, it's more like my mom to me, you know what I'm saying?
Yeah, I understand. Sometimes you can take care of family and then social security or someone will pay you, so I don't know.
Right, no, I'm not getting paid for it. Like I said, it's more like a mom to me.
So are you able to live on with her, you know?
Yes, I'm living there now.
But you get your needs met, food, clothing, all that?
Yes.
Okay.
That's who's actually been helping me through this case, you know what I'm saying? Helping me pay for the drops and the breathalyzers, all that stuff that I've been on when I was just on the tether for the last 2 years.
Okay. Okay, sir, I'm gonna give you a $10,000 PR bond. You'll report to pretrial services. You'll continue as you've been doing as directed by them. You'll have a jail GPS tether, should be with the indigency grant, and pretty sure you'll qualify.
Is it, because I have a bridge card, do they accept that still?
Yep.
Okay.
Yep. You shall not use, possess, consume, purchase, or be in the presence of any illegal drugs, alcohol, or drug paraphernalia. You'll show all prescriptions to pretrial services for medication, from a licensed medical physician, and take those as needed, and any psychotropic recommendations for meds or counseling, community mental health, whatever. If you've got any of that going on, you need to follow doctor's recommendations. You will PBT and/or drug test as requested by pretrial services, law enforcement, any court officer, or your aunt. You will not own, use, have under your possession or control a weapon or gun, ammunition, imitation of a weapon. You'll not be in the presence of anyone who has those items. You'll not be in the presence of any known gang members. You'll not wear any gang colors, insignia, or gang tattoos. You'll maintain your current residence, and any address change will be reported to pretrial services, the court, and your counsel within 24 hours. You will appear for all hearings and proceedings. The next one is January 21st at 9:30. Does that meet with your schedule? He's gonna be out, so it's not, I don't see it's an emergency.
That's fine, Judge. January 21st, at what time you said, 9:30?
Yeah.
January 21st.
Oh, you know what? Yeah, that's right, January 21st.
Yeah, I can be here. I gotta be here that morning anyway.
Great. So that'll be I'm gonna put pretrial / plea, I don't know.
That's fine.
Okay. And you'll not have any contact with the victim. And is there anything else I need to order?
No, you're not.
All right.
We're gonna need a copy of this.
Thank you, Judge.
I was just a little confused. You said victim, I'm like, victim?
Yeah.
Well, there's the officer. I don't know that you know the officer, but you know.
No, I don't know.
Okay.
Just make sure we get out of control service.
All right.
Okay.
Just checking that out.
Within 24 hours of all pretrial services.
Okay.
Yeah, if you got any questions, you got.
And then how much?
Okay.
We'll figure it out.
And how much jail credit?
What day did you go into jail, do you know?
27.
27? So I think Judge, if he,
That's 25th.
So 10 days?
Eight days.
nine, I give him 9.
No, 6, 7.
9.
I think it's,
No one has, isn't it 10?
5, 26, 27, 28.
You, how many lawyers does it take
Oh,
to count?
9 days. 9 days.
I think it's 9 days.
Apparently just one defense attorney.
Okay.
I'm like-
I was gonna give it an extra day. All
I mean,
right.
we'll take 10 if you're handing them out, but.
There's 2 for him, that's right.
Perfect, thank you.
Oh, you know why? Because I was counting that November 31 days, so it doesn't.
Okay, so these are for you, all right, so that's just a copy of your bond conditions, it's all the same stuff you had before, that's a copy of your bond conditions. And that's, you and I have talked before then, but that's a notice